Williams. It's a DWI. We just need to get medical records released. They're going to file the motion. I just wanted to approach to see if we can make note of it so that it can be done in between time instead of when we come back for that release.
You mean
There's
have medical records ready to give to them?
Yes, and we just need to file the motion.
Okay, so go ahead, file it, I'll sign it. As soon as you file it, I'll sign it. So it's old though, it's 184 days old. Do you have an offer?
we're supposed to be trying to get PTI on it. She did a TRAS the last.
So first apply, don't just get the TRAS because, there's a lot of changes that have been made. So I've seen more denials now. So,
She's already done the TRAS.
oh, she's already done it.
Yeah, I had her do it when she was here last time because her appearance had been waived. So
Tell me, is blood test?
it should be blood from, it was a hospital visit. So yeah, there was blood. It was like a point
What
one.
is it? What are the results?
7, I believe. It's a point 1.
I'm curious to see whether she's approved or if she needs a medication packet.
It was 10125.
What is it?
125.
Okay, so it's not.
I did have mitigation. I need to scan everything and send it over. I got, it
Accident?
was an accident.
Accident.
She ran into the back of a tow vehicle.
I think they
But still an accident.
still going to need it. Like, since, they're going to want insurance and all that stuff.
Right.
How much time do you want?
I can't hear you, Judge.
Shh. How much time do you want?
I don't, a couple weeks is fine with me. I don't need.
So
Maybe.
what I would, so can you get the records to her today? Please file the motion. I'll send it now. That way we're ready with that. And then in the interim, we'll give you 2 to 3 weeks.
Okay.
But the next setting, if you can have everything turned in, and then that way we'll wait for a response, whether approved or denied. And I mean,
And then I have a question for you, Judge. Her license is valid now. And can she drive? She wanted me to ask for permission. Last time you told her to ask before doing anything. She's working, but Dad is taking her back and
I would
forth.
ask is just make sure that she has liability insurance, right? Make sure she has car insurance. If she has car insurance, then I'm okay
Dad
with
just
it.
told me he
As long
put
as
her
the
on.
license is clear and she has insurance, I'm okay with it.
Okay. Just want to document it. It's fine.
Alicia, on Raquel Williams, we ordered no driving. Can you confirm with her now? Ms. Moore? Sorry. Can you confirm with her now? Does she have insurance now?
Dad replaced her on. I confirmed with him. He was here last setting with her, and they were ready to confirm it then.
So they have car insurance?
It's not. Let me find out if he actually, because I told him that last time. Judge is going to want to know you have it already.
As long as she has car insurance, I'll amend the conditions to allow her to drive.
Okay. Okay.
Yeah. And then after that, if she does, let Felicia know,
Okay.
and then we'll amend the conditions to allow her to drive, and then just get a reset with Billy, and then, yeah. Mr. Butler, are you able to work it out or no?
Work out some of the.
Just the case in general or no?
So they agree that my issue is, good and valid on that first case. And we can talk more about it if you want to.
No, I get it.
Yes, sir. And we can show you for a couple of years if you would like. We can take you right through that second.
I don't think, look, have you seen what he's talking about?
Yes, and I just spoke with,
And is it as in the motion, have you seen this?
That is a transcript.
the
Okay.
facts of the motion are as Lisa says. Yes.
What do you think?
I actually just spoke to Alex and said that case was recently overruled by a new.
It's just that the Erdman case was overruled by the Court of Appeals, the Criminal Court of Appeals in 2012 by a case.
No, this is Serrano.
Besides the Erdman case, the underlying,
You talking about Simon? It didn't overrule Erdman.
they state,
No, it didn't.
and I would like to, we can read it together. I would like to share it with the court. And
Last I checked, a court of appeals out of the Sixth Circuit or something does not overrule the Court of Criminal.
this is the Court of Criminal Appeals, Finan.
I'm sorry?
Finan is out of the Court of Criminal Appeals.
Okay, so tell me what it's, what's it?
One second. So
Obviously, we'll give you time to look at it so you can.
Yeah, no, it's still up to you. I've read fine.
And I'd like to share it with you. So it says the rules developed by Erdman's progeny are contrary to the fundamental rules of determining whether consent was rendered voluntary. Importantly, these rules, like the analysis of Erdman himself, overlook the fact that the voluntariness of consent must be analyzed based on the totality of circumstances. And
That's what Sandoval says, my friend.
Hold on, let him finish.
and no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise, should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control the voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say, therefore, because of its flawed reasoning and the flawed case law that results from it, we overrule Erdman, which is what that Serrano case relies upon, is Erdman.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning, okay, that said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that, good law.
So, and I want to give you time to look at everything, right? But I mean, this is just like right on point with this.
100%.
Right on point, right? So if Erdman is right on point with this, then okay. But if it's not right on point with this, then it's.
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, where an officer gave the improper admonishments that, hey, you know, if you give a breath test, I'm going to take you home.
Okay,
that's
so
what was said.
I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we?
Nope.
Yeah, we need to get up there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please.
Are you going to remove the seven? Consider waiving her signature on that.
Yeah.
Yeah.
Yeah, as long you can confirm.
Right.
Okay, I trust you. All right. We are on the record in cause number 2505428. State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, a.m. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay. So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes.
That's true.
Okay.
We're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Yeah, Judge, so just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, And after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, you know that's not what's going to happen. And Judge, and you know based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case.
Response?
And one other thing,
And if
Judge.
you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion. And the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamps given and using the court's discretion to come to the conclusion.
let me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not been
seen?
overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby, and that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail. And, it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
We have a panel here ready to go. So I don't want to keep them waiting. You know, they've already been waiting for, 30 minutes. So how do you guys want to proceed?
Judge, if it's okay with you, I'm
Are
happy.
you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this
Well,
right after.
the only thing that
I don't want to keep them waiting.
no, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that
No,
there
of
is no
course,
breath
of
test.
course.
So I think we.
I guess we're ready to roll. But and then we can
I
enforce.
just want to keep them waiting. Let's get it started, and then right after we get done with the paneling, then we can.
Sure.
And then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the 2 outstanding case law that we have.
For sure. Okay. Any lawyers want to approach real quick before